This is online lecture 4 for Political Science 329, 529, Civil Liberties and the Constitution. Today we are talking about some of the early development of freedom of speech. So when we talk about the First Amendment's free speech provision, what we have to be mindful of is that not only is this a developing area of the law, but that the area of the law that's developing has certain questions that are just constantly in flux. So what speech is seems like a simple question, but as we'll see throughout the next couple of weeks, it really isn't. There are protected types of speech, unprotected, and an area that is semi-protected. And then depending on the type of speech involved, the protection varies from place to place. And sometimes the issue might be who is the speaker, and we will get to that by the time we finish up our free speech discussion. Now, some of the earliest tests used in the First Amendment is this idea of prior restraint, that what the First Amendment really means is that government just can't stop you from talking before you talk. And prior restraint has been, as was said in The Big Lebowski, roundly rejected by the Supreme Court. But that does not mean that's where the protections begin and end. So as we go through the tests this week, what I will be doing is sharing with you a continuing graph like this, which adds to our list of tests. So the first is that prior restraint, that the government cannot prevent the occurrence of speech before it happens, either by requiring you to clear it through them or register with them in some certain way, or through judicial injunction. That brings us to the clear and present danger test. This is a case, Schenck versus U.S., that happened in 1919, and the issue is whether a young Mr. Schenck could be arrested under the Espionage Act for distributing a pamphlet, which you see to the side here, resisting those who were drafted to, or encouraging resistance for those who were drafted. And the question was whether he could be arrested and charged with this, given our First Amendment freedoms. And the court said yes. Now, what's interesting here is not that the court said yes. The court could have said yes without setting up another test, but they did. Justice Holmes, writing for the court, said that free speech is not limited to prior restraint, but instead you have to look at the context of the speech. And this, quite honestly, can be the key for this entire free speech discussion from here through March for us. Which is the context is key. If you remember nothing else, just remember that context is key. And so one of those famous lines from a Supreme Court case was written by Justice Holmes in this very case, saying, "The most stringent protection of free speech would not protect a man falsely shouting fire in a theater and causing a panic." So there are things that the government can prevent. And what the test is a test that would determine whether or not there are words used that create a clear and present danger, and that they will incite people to create evil that Congress has the right to prevent. And so this case was used 2 other times, that term, in the Frowork and Debs cases, to uphold convictions of socialists or communists on the basis of laws like the Espionage Act. So the Frowork case had at its heart newspaper articles calling policy towards Germany imperialistic. The court upheld the conviction there. And in the Debs case about Eugene Debs, this involves speech by the leader of the U.S. Socialist Party. So they actually prevented him from giving a speech, and they found this to be acceptable. So we add the clear and present danger test to our list here. The government can restrict speech when the words are used in such circumstances and are of such nature to create a clear and present danger that they will bring about the substantive evils that Congress has the right to prevent. Now, when you think about what Congress has the right to prevent, it really depends on how you're interpreting this, which is, again, why context is key. But in this case, when you're talking about Schenck and you're talking about resisting the draft, what the court said is that the draft is something that Congress is allowed to do through its powers to declare war, and therefore they can also do this to reinforce those powers. But what's interesting is that the clear and present danger test was not kind of a long-standing test that really gave us a good way to look at our cases in front of us. In fact, the same year, but the following term, so it would be like if we had a case decided in spring about something, and then in the fall we sort of went around that case. We have one case, the Abrams case, which signaled that the court is no longer looking at clear and present danger exclusively, but something called bad tendency. And this case involves the same act, the Espionage Act. And the issue here is whether convictions under the Espionage Act for encouraging a general strike amongst citizens, what these were communications that urged people just to sit down where they were working. And they also criticized the president, President Wilson, if these were acts that you could arrest and charge someone with under the Espionage Act, or if that violated First Amendment rights. And the court held that those convictions are okay, that the constitutional prevention of government action around free speech did not come into play here. And this is why the bad tendency test had to be used. These general strikes don't threaten anything specific. You could argue that if Rosie the Riveter, although this was pre-Rosie, didn't rivet the plane, and then the plane didn't get made, and then the plane didn't go overseas to, help fight in the war efforts, that there was a direct connection, but that's pretty tenuous. So they couldn't use clear and present danger. So they had to go back to a test that they had used before in 1907 called the bad tendency test. And the bad tendency test says that government can restrict speech that has the tendency to cause or incite illegal activity. And so you can see how that's a lot looser than clear and present danger. It doesn't specifically overrule Schenck, although it certainly signals that it's no longer binding on future decisions, at least for now. So we get a series of cases that come in between that tend to uphold this bad tendency test. And that's where we get Gitlow from. And the issue in Gitlow is whether Gitlow's conviction under a New York statute about criminal anarchy for participating in groups, socialist groups that called for the overthrow of capitalists, whether that conviction was constitutional or whether it violated his First Amendment rights. And the court held that that conviction was constitutional. And they used the bad tendency test to do so, that advocating criminal anarchy and an overthrow of governmental systems was enough to get you convicted under this law, and that law was valid. Holmes was still on the court, and he roundly decried this in his dissent, but he did not win the day. Also of note is the Whitney versus California case. So in Gitlow you have someone who actually is in possession of pamphlets and possibly distributed these pamphlets. In the Whitney case, you have even less of a connection. And the connection is just that someone had attended meetings and possibly been a member of a socialist or communist group. And the court said that mere membership in one of these groups can be punished, that you are not protected by your First Amendment rights. So you can see the lengths to which the court was willing to go in some of these cases to uphold governmental restrictions. So we then add bad tendency onto the end of our list. The government can restrict speech when that speech would have the tendency to cause or incite illegal activity. In a case that has nothing to do with free speech, we get a footnote that changes the course of our case law in a few areas, but in this one in particular. This U.S. versus Caroline Products Corp case is it is a constitutional case, but it's not a case dealing with civil liberties or free speech. So why bother studying it here? Well, this famous footnote, footnote 4, introduces us to this idea of the preferred freedoms doctrine. And the preferred freedoms doctrine says that there are some freedoms so integral to our state of being as a country that they cannot be abridged by the government. So in this case, we have a completely separate case, but we have this footnote, and it gives us 3 important components of this doctrine. So what this means is that this is how the court is going to look at these preferred freedoms, of which free speech is one. So first, the usual presumption of constitutionality of government action is lessened. When government acts, the presumption that it is entitled to when the act is challenged in court is that the act is constitutional. So if someone sues the state of Michigan for enforcing a law about speech and they go to a federal court, the state enjoys a certain presumption that what they do is constitutional. But that presumption in cases having to deal with fundamental freedoms is lessened because of the importance of this fundamental freedom. Second is that the judiciary has a special duty to defend the civil liberties and rights of individuals. And so, that being the case, the judiciary should be willing to extend itself to situations that might not be so pressing if it did not deal with these civil liberties and civil rights. So this is not a pure statutory interpretation case. This is something more than that. And then finally, SCOTUS, the Supreme Court of the United States, in particular has a special role to play protecting the rights of minorities and special groups. That this is the end of the line for a lot of people, is the Supreme Court. And so the Supreme Court recognizes that sometimes if they aren't the one to say it, it won't happen. And so to uphold our system of government, the Supreme Court needs to be that final check in the checks and balances. So, like I said, this has nothing to do with free speech other than to set up this preferred freedoms doctrine. But how we implement that really depends on what era we're in. As you can see, this case is from 1951, the Dennis versus U.S. case, and this is whether it is within the power of Congress to prosecute people under the Smith Act, which prohibited people from advocating the overthrow of the government. And these were 11 leaders from the National Board of the Communist Party who were indicted for conspiring to teach and advocate for the overthrow of the government by force and violence. So they were charged with conspiring to get together to teach about overthrowing the government. So you see how there's a few steps there. This is not exactly the clear and present danger test. And the Smith Act prohibited anyone from advocating for the overthrow of government, so the government charged them with a violation of the Smith Act. But is that constitutional? The court held that it was. And the reason they held it was is because it's within the power of Congress, according to the court, to protect the structure of the nation. But the means must be narrowly tailored to do so. What the court really hinges on is that that Congress does not have to wait until people are armed and in the streets to stop this from happening. It is within the power of Congress to go out and stop the willful advocating or teaching of this so that they don't have to fight this in the streets. This, however, gets one of these important dissents going, and this is from Justice Douglas. And Justice Douglas was pretty concerned with how far this interpretation of the law would go. And he introduced an idea into our judicial canon about this marketplace of ideas. If you have a system where you are going to restrict, what you're doing is actually encouraging bad ideas to gain traction. Instead, if you flood the system with ideas, people will pick the marketplace of ideas, and they will pick the ideas that they like the most. Now, this is obviously the cartoon to the side is sort of a what if we did this, and people, do tend to like the comforting lies more than the unpleasant truths. But that's kind of the idea of the marketplace of ideas. If something doesn't gain traction, then that's okay. The idea of having freedom of speech is so we have a marketplace of ideas. And so this really frightens Douglas. And what becomes the next set of tests comes about because you have people who are starting to be concerned about the way that the First Amendment was implemented and looked at in the World War I, World War II era. So you get the Warren Court in, and if you don't know what the Warren Court is, it is the court that took place during the tenure of Chief Justice Earl Warren. And they are known as being a fairly liberal court, especially on civil liberties and civil rights issues. And the Brandenburg versus Ohio case is one of those cases that can really cut both ways. It really is what could be called a free speech absolutism case. And Brandenburg deals with a rally in Cincinnati by the Ku Klux Klan. And the Ku Klux Klan held this rally, and not only did they just hold a rally with their robes and their marching chants and all of that, but one of the leaders was videotaped by a local news station talking about how they are planning on another March on Washington, and that at the March on Washington, essentially people should beware because these are people that own guns and we're willing to take back our country by whatever means are necessary. So it was, in a way, a threat. But was it a threat enough to be punished by this Ohio criminal syndicalism statute? And the court found that it was not. So in other words, the KKK can have their rally and can say things like this. And the reason they find that it's not is that a state cannot forbid advocacy of the use of force or violation of law except where such advocacy is directed at inciting or producing imminent lawless action and is likely to produce imminent lawless action. So let's break that down for a minute. This is a reinvention of the clear and present danger test because mere abstract teaching is not enough to be punished. So you need something more. You can't have one lone member of the KKK saying, we're going to take down the government. You have to have a plan in place and a likelihood that that plan is going to come to fruition. So, you can see from this cartoon here, you can really say a lot just within the framework of Brandenburg without being outside the bounds of good decency, which presents a lot of problems. I mean, it's one thing to put down a popular political idea and people get up in arms, but what about an unpopular one? And how much weight do they pull? So we can add kind of the Brandenburg clear and present danger test onto there. It really is the clear and present danger test, but it was rewritten a little bit, so we should distinguish it to some degree. So we add that to the bottom, that speech can be prohibited if it is directed at inciting or producing imminent lawless action and is likely to incite or produce imminent lawless action. So, I'm not going to go further into any other cases this time. I'll pick up at this point in terms of cases for the next online lecture, even though your reading goes a little bit further than this. What I want to do is break down the elements of the test that we will be looking at time and time again where speech or expression are at issue. And it's really a three-part test, which shouldn't seem so uncommon at this point. The first thing you do is you look at the type of speech that's at issue. If you have unprotected speech, none of this matters. You stop right there. There are certain types of speech that are not protected, which we will talk about in a minute, that we don't need to look into the rest of this. Government action is perfectly okay. Then you have semi-protected speech, which is commercial speech, and we'll talk about that in a couple of weeks. That is entitled to some protection. And then finally, we have protected speech, and there are some protected speech elements that are more protected than others. So political speech is one of the most protected forms of speech we have. So let's say we have a piece of political speech. The next step is to look at the purpose of the regulation. What is it that the government is trying to regulate or stop? And so there we'll talk about the difference between content and viewpoint regulations and time, place, and manner regulations. And then finally, is the regulation having an effect that is impermissible? So is the regulation too broad, too vague, or has a chilling effect on otherwise acceptable speech? So let's break this down. I'm going to break down the nuts and bolts of this test. And then we're going to keep reading the cases for next week, and we're going to be applying this test over and over again. So don't be surprised to see this in different forms. So when we're talking about types of speech, there are some types of speech that have less protection than others. So I mentioned that political speech is held in pretty high regards, and other matters of social or political nature, that's pretty much the top of the line. But what's the bottom of the line? Well, defamatory and false speech about another individual that we'll talk about in a little bit is not protected. So you cannot claim that I am a convicted murderer. I am not. It's false and defamatory, and that is not protected. So you can't then, when I go to sue you for that, you can't say, well, First Amendment. There's no First Amendment protection. Obscenity. Language that has no other purpose other than to appeal to the prurient interest or lacks serious political, social, scientific value. That is unprotected, and we will spend some time talking about what is this prurient interest and what does it mean to lack value. Criminal speech. There are certain things that you can say that are crimes in and of themselves. So the type of thing I'm talking about is a conspiracy to commit murder. The speech that is part of the elements of that crime is a crime in and of itself. To talk about how you're going to commit murder is a crime. So that is not protected. Violence and threats that are imminent and incitement are not protected. And then we have this commercial speech, and we'll spend a few cases on commercial speech, but it is entitled to some protection, just not the type of protection political speech would be entitled to. So, when we go back to our test, that fills in that first block. What type of speech is at issue? All those unprotected types of speech, don't worry about it. We're done with the test. No more. You can close the book and walk away. If it's commercial speech, that's going to vary a little bit based on some factors that we'll talk about in the next couple of lectures. If it's protected speech, we need to go further. And the next step is to look at what is the government trying to regulate. So we have two broad, although they're not all-inclusive, ways that government can try and regulate speech. And this is really, what is the government's purpose? What is their intent? So if their intent is to merely prescribe when you can say something, or the volume at which you can say something, or the boundaries of the place you have to be while you say something, that's called a time, place, and manner restriction. But if the restrictions have to do with the identity of the speaker, the subject matter of the speech, or the viewpoint advocated in the speech, that is impermissible because it is content or viewpoint restrictions. So, let me give you an example. If I am talking about how abortion is a moral injustice and needs to be eliminated. The government cannot stop me from talking about that because I am a woman. Furthermore, the government cannot stop me from talking about it because it deals with abortion. And finally, the government cannot stop me from talking about it because I am advocating one side of an issue. However, I cannot make this speech everywhere at the same time, at the same volume. So I can make this speech in the middle of a public park or a college campus, and I can have a bullhorn in the middle of the day. But I cannot go through a residential neighborhood at 3 a.m. Making the same type of speech, and so with a bullhorn and waking people up. So you can see how time, place, and manner and content or viewpoint restrictions can come into play with the same scenario. And so it's so important to determine what really is the government's intention. Are they intending just to limit the time, place, and manner? And are they doing it as narrowly as possible? Or are they really just trying to regulate what people say? If they are trying to regulate what people say, or who says it, or what viewpoint they take, that is something the First Amendment does not allow. But the First Amendment does allow time, place, and manner restrictions. So that is that middle part of this. They cannot regulate the content or the viewpoint of the speech, but they can regulate time, place, and manner. Next, we have to look at if they can regulate. Is that regulation narrowly tailored? So it really is the effects prong. If they are allowed to regulate, if the purpose is acceptable, they still cannot regulate if these things happen. One of those things is to be overbroad or overbreadth. If a regulation is too broad and captures too much speech, it is impermissible. You have to have a government regulation that is narrowly tailored to meet a valid governmental purpose. So, if they are making a regulation about talking about abortion, in general, that's too overbroad. But if they're making a regulation about talking about abortion in front of an elementary school, perhaps that is a bit more tailored. Although probably not in our political climate, but let's just use it for an example. Next, one effect cannot be that the regulation is vague. People have to know what is regulated and what is not. If they don't, or they can't tell if what they are about to say is going to cause them to go to jail or not, then it is too vague, and it fails as a matter of constitutional law. So it cannot be overbroad, and it cannot be vague, and quite often these things go together, because you don't know if it's overbroad or vague, or maybe it's both. So you'll often see it together. The final one is something called chilling effect. Government cannot regulate speech to the extent that it scares other people who might otherwise speak in a lawful manner from speaking. So, if government goes around shutting down all kinds of speech, that's going to prevent people from speaking openly about things. And that is something that the Supreme Court does not look on too kindly. So, we will leave our discussion there today, talking about the elements of that test. There are a few more cases, as I mentioned, that come after this in this section, but you can apply the test, and we will go through those in the next online lecture. So, as we start to think about this, that's the test we'll be using, with these ideas of how the test has developed over time. And now what we're going to do is start looking at elements of that test in a little more depth. So I will see you in class.